Let's begin with the 30-second countdown.
Seven, 6, 5, 4, 3.
The Subcommittee for the Indigenous Peoples of the United States will now come to order. The subcommittee is meeting today to hear testimony on H.R. 437, to amend the Alaska Native Claims Settlement Act to exclude certain payments to Alaska Natives, elders, for determining eligibility for certain programs and for other purposes, introduced by Representative Young of Alaska. H.R. 6063, to provide for the equitable settlement of certain Indian land disputes regarding land in Illinois and for other purposes, introduced by Representative McCollum of Minnesota. The discussion draft ANS to H.R. 6181, the Samish Indian Nation Land Reaffirmation Act, introduced by Representative Gallego. S. 314, the Klamath Tribe Judgment Fund Repeal Act, introduced by Senator Merkley of Oregon. S. 559, to amend the Grand Ronde Reservation Act and for other purposes, introduced by Senator Merkley of Oregon. Senate 789, repealing existing substandard provisions encouraging conciliation with Tribes Act, introduced by Senator Mike Rounds of South Dakota. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chair and the ranking minority member or their designees. This will allow us to hear from our witnesses sooner and help members keep to their schedules. Therefore, I ask unanimous consent that all other members' opening statements be made part of the hearing record if they are submitted to the clerk by 5 p.m. today or the close of the hearing, whichever comes first. Hearing no objection, so ordered. Without objection, the chair may also declare a recess subject to the call of the chair. Hearing no objection, so ordered. As described in the notice, statements, documents, or motions must be submitted to the electronic repository at hnrcdocs@mail.house.gov. Members physically present should provide a hard copy for staff to distribute by email. Please note that members are responsible for their own microphones. As with our fully in-person meetings, members can be muted by staff only to avoid inadvertent background noise. Finally, members or witnesses experiencing technical problems should inform committee staff immediately. I will begin by recognizing myself for my opening statement. Good afternoon. Today's legislative hearing will be on 6 bipartisan tribal bills. H.R. 6063, to provide for the equitable settlement of certain Indian land disputes regarding land in Illinois and for other purposes, was introduced by our colleague, Representative of Minnesota, Ms. McCollum. Before forced relocation, the Miami Tribe of Oklahoma, Eel River, and Rio tribes signed the Treaty of Grossland of 1805, establishing that without the consent of all three signatories, the tribes had not ceded land south of the Great Lakes in the Wabash River watershed. Following the signing, the United States violated the treaty by placing land in the public domain and transferring parcels to colonial settlers without the consent of all the tribes. H.R. 6063 will extinguish the Miami Tribe of Oklahoma's land claim to Illinois land for 1 year to bring its case before the United States the Court of Federal Claims. Our next piece of legislation is a discussion draft amendment in the nature of substitute, or ANS, for H.R. 6181, introduced by Mr. Gallego of Arizona. H.R. 6181 will take approximately 6.7 acres of land into trust for the Samish Indian Nation, reaffirming a November 2018 decision by the Department of the Interior. The draft ANS we are deliberating today removes the reference to the November 2018 determination and reaffirms the application of the Indian Reorganization Act to the nation. In 1969, the Samish Indian tribe lost federal recognition due to a clerical error by the Bureau of Indian Affairs and regained federal recognition in 1996. Following the reestablishment of federal recognition, the nation has worked to restore its land base through the fee-to-trust land process. However, the 2009 Carcieri decision decided that the Secretary's authority to place land into trust applies to tribes holding federal recognition in 1934 and complicates the process. The Secretary approved the decision to take land into trust for the benefit of the Samish Indian Nation in November 2018 after a 9-year analysis in which they determined it was the nation had fulfilled the criteria under the Reorganization Act. The discussion draft ANS of H.R. 6181 reaffirms the Indian Reorganization Act of 1934 applies to the Samish Indian Nation. Our colleague, Senator Merkley of Oregon, introduced the following two bills, S-314 and S-559. First, we have S-314, the Klamath Tribe Judgment Fund Repeal Act. S-314 will repeal the Klamath Tribe Judgment Fund Act to provide the Klamath Tribe's authority over judgment funds. During the termination era, Congress passed the Klamath Termination Act of 1954 to terminate the Klamath tribes. As a requirement of this act, the Klamath tribes submitted the final roll of tribal members to the Secretary of Interior to distribute the monetized funds of tribal land and property. At the time of termination, the Klamath tribes also had pending lawsuits to seek compensation for the mismanagement or misappropriation of tribal assets before the Indian Claims Commission. The Klamath Termination Act did not extinguish these claims, leaving tribal members on the final roll eligible for a share of the funds. Final judgment for the claims resulted in the requirement of congressional authorization and appropriation. Rather than addressing each claim, Congress passed the Klamath Tribe Judgment Fund Act to direct the Secretary to make per capita distributions. The distributions would go to all eligible tribal members and heirs based on the final roll and removed the authority of the Klamath tribes to self-govern over their funds. In 1986, the United States restored the federal trust relationship with the Klamath tribes. As the Klamath Judgment Fund Act did not account for the restoration of federal recognition, it continues to prevent the distribution of funds for the benefit of members and tribal priorities. S-314 will restore the Klamath tribe's right to self-government, the management of their funds. S-559 will amend the Grand Round Reservation Act to clarify the tribe's land claim authorities in Oregon by striking language that voids the tribe's right to bring forth land claims in Oregon. In 1984, the Bureau of Land Management, or BLM, identified a survey error from the 1800s that resulted in the BLM managing and holding in trust an 84-acre parcel of land. The tribe determined this parcel, the Thompson Strip, was unmanageable as of its narrow boundaries and proximity to land held by other interests. Through negotiations with BLM, Grand Round reached an agreement to transfer the Thompson Strip in exchange for 240 acres of land adjacent to the reservation. In codifying this land transfer, language was included in the act that wrongfully voided the tribe's right to bring forth land claims in Oregon. S-559 would correct the Grand Round Reservation Act to ensure that the Grand Round's relinquishment of land claims applies to the Thompson Strip. Next, we have S-789, introduced by Senator Rounds of South Dakota. S-789, the repealing existing substandard provisions encouraging conciliation with Tribes Act, would repeal 11 antiquated federal laws about American Indians and Alaska Natives. While today's laws promote tribal sovereignty and self-determination, at its founding, the policy of the United States to forcibly remove and assimilate tribal communities. S-789 will address several discriminatory federal laws that reflect the history of violence perpetrated against American Indians and Alaska Natives by the federal government. Lastly, we will hear H.R. 437, introduced by our late Dean Young of Alaska, to amend the Alaska Native Claims Settlement Act to exclude certain payments to Alaska Native elders for determining eligibility for certain programs. In 1971, Congress passed the Alaska Native Claims Settlement Act to address land claims in the state of Alaska. Under the settlement agreement, the federal government transferred 44 million acres and $962.5 million in compensation funds to the newly established Alaska Native corporations. ANCSA expressed that no provision within 2C would diminish Alaska Natives' rights as citizens of the United States and the state of Alaska, or the obligation of the United States and the state of Alaska to protect the rights and welfare of Alaska Natives as citizens. Following this provision, ANCSA was amended in 1976 to exclude the first $2,000 Alaska Natives received from ANCs in the determination of eligibility of the recipient for need-based federal programs, and this has remained unchanged. With further amendments, Congress failed to exclude settlement trust in such funding to determine eligibility for need-based federal programs, forcing Alaska Native elders to choose between receiving the settlement trust benefits or qualifying for need-based federal benefits. H.R. 437 would amend ANCSA to exclude ANC benefits provided to Alaska Native elders when determining eligibility for need-based governmental programs. I want to thank our witnesses for joining us, and I look forward to hearing testimony this afternoon. I would now like to recognize Acting Ranking Member Obernolte for his statement from the state of California.
Well, thank you very much, Madam Chair. I am really looking forward to our hearing. This will be our first hearing that's hybrid since the start of the pandemic. It's very nice to see people here in person, and hopefully health conditions will allow us to continue to do that. Also, this hearing is very poignant for me. Obviously, this is our first hearing without our Dean, Don Young. I'm deeply honored to be sitting in his seat here. He did so much for Indian country, and certainly I've got some big shoes to fill. And it's very appropriate that our first piece of legislation that we're considering is one that he authored. It's H.R. 437 to exclude amounts provided to Alaska Native elders age 65 and older from the Alaska Native Settlement Trust when determining eligibility for some government benefits. When Congress established the ANCSA in 1988 to authorize Native corporations to establish settlement trust, it did not exclude those benefits for determining eligibility. And according to several ANCs, and I'm sure we'll hear that testimony today, this discrepancy between the types of income from ANCs can place many Alaska Native elders in the position of having to choose between accepting settlement trust income on the one hand or qualifying for government assistance on the other, and obviously that's not a situation we would want to put anyone in. The second bill on our agenda, H.R. 6063, seeks to resolve the purported land claims of the Miami Tribe of Oklahoma by conferring exclusive jurisdiction over the tribe's claims to the U.S. Court of Federal Appeals. Now, it's worth saying that legislation like this bill is relatively uncommon due to the finality of the Indian Claims Commission on Historic Lands prior to 1946, and I'm hopeful that this committee will exercise care and discretion with its consideration of this bill due to the broader implications that this might have and the impacts it might have on gaming. Our third bill, which is discussion draft ANS to H.R. 6181, would reaffirm that the IRA applies to the Samish Indian Nation. This draft ANS would, on its face, provide for the applicability of the IRA to the Samish Indian Nation. Now, it's my understanding that several tribes in Washington have voiced concerns over the implications that this bill has introduced and the ANS might have on their treaty rights. I'm sure we'll be hearing from them today. While the ANS would not directly ratify the 2018 BIA decision and the accompanying Carcieri analysis, as the bill as introduced would have done, I am still concerned by the use of the word reaffirmed, and I am worried that it might be construed to mean that what is being reaffirmed is the DOI decision. So hopefully we can clarify that. One way or the other, I think that this committee should exercise caution in consideration of this bill due to the implications on what are now settled treaty rights in case law spanning the past 40 years. Based on previous testimony from the Department of the Interior, and the testimony that we have received in writing for today's hearing, I think that all parties would benefit if we request that the Department of Justice provide this committee with its views on whether or not H.R. 6181 and the ANS would affect the DOJ's legal rights in treaty litigation. And so, Madam Chair, I think that might be something that we should look into. Our fourth bill, S314, would repeal the Klamath Judgment Fund Act and require that the remaining $600,000 in the fund be transferred to the Klamath tribe. Madam Chair, you did a wonderful job summarizing that. I think that's it's only fair that we consider that. Our fifth bill, S559, will amend current law to reflect that the Grand Ronde tribe's extinguishment of land claims only applies to an 84-acre parcel of land known as the Thompson Strip. Now, it's my understanding that two tribes have expressed concerns about the gaming prohibition language consistency with the stated intent of the bill, and I'm hoping that this is something that we'll be able to discuss in the hearing today. And finally, our last bill, S789, would repeal 11 statutes related to the treatment of Indians. If you read those statutes, I find them undeniably racist and deeply personally offensive, and I'm very happy that we are considering purging the federal code of those statutes today. So I want to thank our witnesses for joining us today. I'm looking forward to hearing their testimony, and Madam Chair, I yield back.
Thank you, Ranking Member. I ask unanimous consent that Representative Schrader of Oregon and Representative Mullen of Oklahoma have permission to sit on the dais and participate in the hearing. Hearing no objections, so ordered. Now I would like to transition to our panel of witnesses for today. Before introducing them, I will remind non-administration witnesses that they are encouraged to participate in the Witness Diversity Survey created by the Congressional Office of Diversity and Inclusion. Witnesses may refer to their hearing invitation materials for further information. Under our committee rules, oral statements are limited to 5 minutes, but you may submit a longer statement for the record if you choose. When you begin, the on-screen timer will begin counting down and will turn orange when you have 1 minute remaining. I recommend that members and witnesses joining remotely lock the timer on their screen. When you go over the allotted time, I will gently nudge you to wrap up your statement. After your testimony is complete, please remember to mute yourself to avoid any inadvertent background noise. I will allow the entire panel to testify before we question the witnesses. The chair now recognizes Ms. McCollum to introduce the first witness.
Thank you, Madam Chair, and greetings to all my subcommittee members. I am pleased to introduce today the Miami Tribal Chief, Doug Langford, and he's going to be testifying in support of H.R. 6063. Chief Langford has served the tribe since 1998 and as tribal chief since 2012. And before that, he was sub-chief. In his spare time, Chief Langford serves as the tribal IT director and vice chair of the Intertribal Council of Northeastern Oklahoma. Chief Langford has worked to enhance healthcare and elder care for the tribe, sustainable farming on the tribe's reservation, as well as strengthening the tribe's connection to its members in Kansas and in Indiana. Chief Langford has also worked to enhance the tribe's historic relationships with the Miami University in Oxford, Ohio, and the development of the Miami Center at that school, which advances education in Miami languages, culture, and serving dozens of Miami tribal member students. Now, Chief Langford's also a proud father of 2 boys and 8 grandchildren. So, Chief, welcome to the Subcommittee of the Indigenous Peoples of the United States. We're proud to have you here.
Thank you.
Thank you, Madam Chair.
Thank you, Representative McCollum. The chair now recognizes the Honorable Doug Langford, who is the chief, as we've just heard, of the Miami Tribe of Oklahoma.
Thank you, Madam Chair, and thank you for that warm introduction, Congresswoman McCollum. Aya Akim Echapunguya Waynes Wani Nila Miyamia. I'm Chief Langford of the Miami Tribe of Oklahoma. I want to thank the subcommittee for this opportunity to testify in support of H.R. 6063. This bill resolves the tribe's land claim in East Central Illinois by doing 2 things. First, it gives the United States Court of Federal Claims the authority to decide whether the United States took land protected by the 1805 Treaty of Grassland without paying the tribe. Second, it extinguishes the tribe's claim to those lands, which forever eliminates the clout on title for landowners. Excuse me. The Miami tribe's seat of government is located in Ottawa County in northeast Oklahoma, but our ancestral homelands span the states of Indiana, Illinois, and Ohio. In 1846, the tribe was forcibly removed from its homelands to the Kansas Territory, and 20 years later, again forcibly removed to Indian Territory, now the state of Oklahoma. In 1805, the Miami signed the Treaty of Grouseland. By Article 4 of that treaty, the tribes reserved land in the Wabash River watershed, and the United States agreed that they would not take additional lands in the watershed without the consent of the tribe. Between 1805 and 1840, the Miamis entered into several treaty ceding most of its homelands, including some land reserved under the Grouseland Treaty. A significant part of that reserve land, 2.6 million acres, located in east central Illinois, was never ceded to the United States. Despite lacking title, the United States sold reserve land to non-Indian settlers. As a result, the United States did not transfer good title to the land, and its actions give rise to the Miami's claim to these lands, and it created clout on title on these lands. H.R. 6063 represents a common sense, mutually beneficial resolution to this problem. The bill would extinguish the tribe's land claim, resolving the clout on title, and it would grant the tribe 1 year to bring its case before the United States Court of Federal Claims. To be clear, passage of this legislation extinguishes the Miami land claim, and the clout on title is cleared regardless of the tribe's success in litigating its claim before the court. When the tribe asked Congressman Don Young to co-sponsor the bill years ago, he looked me in the eye and said, "So the farmers get relief, but the tribe still has to prove its case. Are you sure that you really want that?" And I said, "Yes, sir." He responded, "Fair enough." Congressman Young was a straight shooter and a tireless advocate for Indian country. He understood the common sense of the bill right away. The tribe has worked closely and diligently with congressional leadership from Illinois, with the local leaders from Illinois, especially those in the affected treaty area, and the Farm Bureau supports this legislative solution. Finally, please note that H.R. 6063 is not a land claim settlement bill or an appropriation bill. The tribe prevails in court, its judgment would be paid from the federal judgment fund. Also, this bill does not evaluate or decide the merits or defenses and does not declare any winners except the landowners in East Central Illinois. Mishinewe, thank you, Madam Chair, committee members, for your time for this opportunity to testify in support of the bill. And a special thank you to our congressional champions, Congresswoman McCollum and Congressman Mullen. I am happy to answer any questions the committee may have.
Thank you, Chief, for your testimony. The chair now recognizes the Honorable Tom Wooten, who is the chairman of the Samish Indian Nation.
All right, thank you, Madam Chairman. Good morning. Good morning from the beautiful San Juan Islands, where we, the Samish people, have always lived since time immemorial. Again, my name is Tom Wooten. I'm the chairman of the Samish Indian Nation, a federally recognized tribe based in Anacortes, Washington, and thank you for this opportunity to testify. We also give thanks to Congressman Gallego for introducing 6181 and have thanks to the 14 bipartisan co-sponsors. In response to questions raised about the bill as introduced, the tribe has proposed this amendment in the nature of a substitute. As you can see, it is short and to the point. The ANS would simply reaffirm that the Indian Reorganization Act applies to Samish. This would allow the tribe to be on equal footing with other federally recognized tribes. The ANS would help eliminate red tape, bureaucracy, and other roadblocks that have severely hampered our efforts to rebuild our community. The ANS is anchored in bedrock principle of the U.S., that all federally recognized tribes should be treated fairly and treated the same under federal law. For over 25 years, the tribe has worked hard to reach out to surrounding communities and tribes to discuss our efforts to secure a homeland. We have a good relationship with Skagit County and the city of Anacortes. Congress passed the IRA in 1934 to revise misguided federal policies that resulted in devastating losses of tribally owned lands. In 2009, the Supreme Court issued the Carcieri decision, creating additional hurdles in an already cumbersome land and trust process. We are thankful that the House passed H.R. 4352, the Carcieri fix. Our hope is that the Senate can pass the fix so no tribe has to go through what we've had to go through. Fortunately for Samish, in 2018, after an extensive 9-year process, the department issued a detailed decision determining that Samish fulfilled the requirements under Carcieri. However, the tribe continues to struggle. Samish has suffered greatly. It was 52 years ago in 1969 that the BIA made a clerical error and left the tribe off the list of federally recognized tribes. It took 27 years of administrative process and litigation for the BIA to re-recognize the tribe in 1996. It took this long in part because nearby tribes like Tulalip tribes litigated against our re-recognition efforts. After re-recognition, it took 10 years before the BIA took 79 acres of land into trust for Samish. This occurred before the 2009 Carcieri decision. It took 9 years after the BIA to complete the Carcieri analysis for the tribe. In 2018, the BIA issued a decision to take 6.7 acres of non-gaming land we own into trust, which is adjacent to our existing 79 acres of trust land. However, the BIA has not taken this land into trust due to litigation delay tactics filed in the Interior Board of Indian Appeals challenging the BIA's 2018 decision based upon the Carcieri decision. This litigation could last over a decade. Meanwhile, our efforts over 20 years to take other parcels into trust, like our administration complex and our longhouse, where we provide Head Start and elder services, have been at a standstill. The Tulalip tribes have long opposed our efforts both legislatively and administratively to take land into trust. In good faith, we proposed this ANS to address their concerns. The ANS would simply reaffirm the applicability of the IRA to Samish, just like it applies to other federally recognized tribes, including Tulalip. The ANS would help right past wrongs, enable the tribe to move forward. Again, I thank you for this time, and I'm happy to answer questions. Hayashkasian. Thank you.
Thank you very much for your testimony. The chair now recognizes Mr. Benz, Representative Benz, to introduce the next witness.
Thank you, Madam Chair. And it's my privilege and pleasure to introduce and welcome Chairman Don Gentry from Klamath County, Oregon, which is in my district. Chairman Gentry serves as the chair of the Klamath Tribal Council, a position he was elected to in 2013. Prior to his current role, he served as vice chair of the Tribal Council for 3 years. I am pleased that Chairman Gentry is here today to testify before our subcommittee, and with that, Madam Chair, I yield back.
Thank you, Representative Benz. The chair now recognizes the Honorable Don Gentry, who is the chairman of the Klamath Tribes.
Thank you so much. Waklisad, greetings. Ditchwaitis, good day. Honorable Chairman or Chairwoman Fernandez, Acting Ranking Member Obernolte, and members of the committee, I thank you for the opportunity to participate in this hearing to represent the Klamath Tribes. Along with this statement, I have submitted written testimony that I request be included in the record of this hearing. My name is Donald Gentry, and I serve as chairman for the Klamath Tribes. And I'm here today to urge repeal of the Klamath Tribes Judgment Fund Act of 1965 in support of S 314. This act exists solely as a remnant of the failed federal termination policy enacted upon our Klamath people in August 1954. The Klamath tribes is comprised of 3 distinct tribal nations, the Klamath, the Modoc, and the Yahuskan Paiute people. There are currently 5,700 members of our Klamath tribes, and our Aboriginal territory includes much of Southern Oregon and Northern California. On October 14th, 1864, the Klamath tribes signed a treaty with the United States relinquishing our right to occupy a territory of nearly 20 million acres of our traditional homeland, and we reserved for ourselves 2.5 million acres at that time. By 1954, through fraudulent land surveys and disastrous federal policies, the Klamath reservation was reduced to 1.2 million acres, of which 882,000 were tribal trust lands. The last remnant of our homeland was stripped from us by the Termination Act of 1954, which ended our federally recognized tribal status. The termination period was devastating and disastrous for our people as a whole and for our individual tribal members. With the rough discontinuation of services, which management of our lands really provided for, it was devastating for us. We had discontinued health services, education, and the unmooring from a collective group caused by termination had significant trauma and impact on our people. Our tribal members faced, among other disastrous impact, increased health disparities that resulted in increased infant mortality and decreased life expectancy of our people. The United States acknowledged the failure of the termination policy in the 1970s, and the Klamath tribes was restored to federal recognition in 1986. In preparation for this testimony, I noted the subcommittee's goal is to protect tribal sovereignty and tribes' authority over their lands and their natural resources, while empowering tribal communities with enhanced self-governance authorities. Please let me tell you how passage of the Klamath Tribes Judgment Fund Repeal Act will allow the full expression of the tribe's sovereignty and self-determination. After Congress passed the Termination Act in 1954, the Klamath Tribe still had a number of legal issues that had not been resolved. In 1958, the Executive Committee of the Klamath Tribes passed Resolution 1958-5, which resolved that the Secretary of Interior would be authorized and requested to establish a separate fund in the amount of $350,000 from any available Klamath tribal funds for the purpose of providing a reserve of necessary funds for prosecution of the Klamath tribe's claims against the United States. This was in reference to docket 100 claims pending before the federally established Indian Claims Commission. During the post-termination era up until 1982, the Claims Committee oversaw a number of legal actions, and these funds that resulted from the positive actions survived and were replenished over time. I see my time's running out, so I'm going to try to close here best I can. The Judgment Fund Act requires that our funds to be distributed in a way that's not at all helpful for us. It limits our self-determination and self-governance to do what our members intend to do with those funds, and that's to distribute those funds to the 54 members that are remaining at this time. Repeal of this Judgment Fund Act will allow us to do that. So I thank you very much for the opportunity and willing to answer any questions when appropriate.
Thank you, Chairman Gentry, and I would also note that for all the witnesses, your written testimony has been received, has been distributed to the committee, and is part of the record. The chair now recognizes the Honorable Cheryl Kennedy, who is Chairwoman of the Confederate Tribes of Grand Ronde.
Chair Fernandez, Acting Ranking Member Obernolte, and members of the subcommittee. My name is Cheryl Kennedy, and I am the chairwoman of the Confederated Tribes of Grand Ronde, Community of Oregon. In 1988, the Bureau of Land Management detected an 84-acre survey error on the Grand Ronde Reservation, dating back to 1871, called the Thompson Strip. Until the survey error was discovered, the BLM permitted timber to be harvested by private timber companies. The land, however, was still held in trust for the tribe by the United States. After being informed of this error, the tribe determined that the Thompson Strip was unmanageable by Grand Ronde because of its narrow boundaries and the fact that it divided the ownership interests among several parties. The tribe sought a land exchange with the BLM as compensation for the loss of this land. The BLM and the tribe agreed to the transfer of 240 acres of federal land as compensation for the Thompson Strip. The tribe also agreed to relinquish its claims to the Thompson Strip. The BLM land transfer and the tribe's extinguishment of its land claims were memorialized in an amendment to the Grand Ronde Reservation Act in 1994. In drafting the language to authorize this land exchange, the Interior Department developed broad language that relinquished any future claims of this type within the state of Oregon. BLM officials at the time expressed concern about the sweeping nature of this language, as it would preclude the tribe from receiving any compensation or participating in a future land transfer should BLM discover any additional survey errors. In agreeing to this land exchange in 1994, the intent of Grand Ronde was to relinquish its rights only to the Thompson Strip and any claims for lost timber income. There were also no intention by BLM or BIA officials involved in this land swap to extinguish the tribe's land claim rights for the entire state of Oregon. These clear intentions are documented in House legislation hearing before the Subcommittee on Native American Affairs held on July 22, 1994, which included testimony from our chairman, Mark Mercier, and Congressman Mike Kopetsky. Our tribe discovered the Thompson Strip issue only recently when working on another amendment to the Grand Ronde Reservation Act. We want to be proactive about ensuring that the tribe has the right to be compensated should another problem arise. As we acquire lands, we sometimes find survey inconsistent when title searches are concluded. The language in S559 is simple. It replaces the phrase State of Oregon with the phrase the 84-acre known as the Thompson Strip. By this language, the tribe would only relinquish its claims to the Thompson Strip, which was the tribe's intent in its 1994 land exchange. It is not Grand Ronde's intention that this technical correction amendment would be used to facilitate Indian gaming or impact Grand Ronde treaty rights or the treaty rights of any other tribe. For this reason, the proposed legislation would prohibit Class 2 or Class 3 gaming on any lands obtained by the tribe as a part of a land claim settlement. Additionally, this technical correction amendment would not enlarge, confirm, adjudicate, affect, or modify any treaty right of a federally recognized Indian tribe. A final point, Grand Ronde understand that a concern has been raised regarding the gaming prohibition language in Section 1 of S559. This concern involves whether Grand Ronde would be able to use any funds provided in a future land claim settlement to purchase land for gaming activities. The language in Section 1 of this bill addresses this issue by prohibiting any real property obtained by Grand Ronde as a part of the land claim settlement to be ineligible for any type of gaming. The use of the word obtained is different from the original Senate bill in the 116th Congress, which only prohibited any real property transferred to the tribe as a part of the land claim settlement. After introduction, Senator Wyden requested the term transferred be replaced with obtained to ensure that the prohibition against gaming would apply to any land purchased by Grand Ronde with land claim settlement funds. This language change occurred in the original Senate committee markup on July 22nd, 2020, and it is the same language that has now passed the Senate twice, once by unanimous consent on December 20th, 2020, and the second time on a voice vote on May 26, 2020, to confirm and ratify Grand Round's understanding and support for this gaming prohibition. Grand Round has recommended committee report language that would explain that the use of the word obtained includes the use of any fund received in a land claim settlement. This recommended language is outlined in a longer statement that's for this record. It is not our intention that there be any concern about using a land claim settlement of any type as a pathway to a casino. Grand Round believes that this classification addresses the concern expressed above, and I want to ensure you that the tribe's position is on the record for this committee. We want to thank you for this opportunity to testify and ask for your support. Hayumasi.
Thank you so much, Chairwoman.
You're welcome.
The chair now recognizes the Honorable Sherry Bureta, who is the chairwoman of the board for the Chugach, Alaska Corporation. Madam Chairwoman.
Shamai, hello. Good afternoon, Chairwoman Lagar, Fernandez, Ranking Member Obernolte, and members of the committee. Good morning from Anchorage, Alaska. I appreciated hearing the recognition to your former colleague and my good friend and beloved fellow Alaskan, Congressman Don Young. I worked closely with Congressman Young for 25 years in my capacity as Chugach Alaska Corporation's chairman of the board, and as a board member of the Alaska Federation of Natives and the ANCSA Regional Association. I'm also a tribal member of the Native Village of Tititlik. I'm honored to be here today to express my support for H.R. 437, a bill that Congressman Young himself fought for on behalf of Alaska Native elders. Chugach is one of 12 Alaska Native regional corporations formed under the Alaska Native Claims Settlement Act of 1971. The Chugach region includes more than 5,000 miles of coastland in the Prince William Sound and encompasses the remote communities of Eyak, Cordova, Seward, Valdez, Port Graham, Chiniga, Nunmalik, and Tititlik. Our corporation represents more than 2,700 Alaska Native shareholders and their descendants. Our purpose is to preserve our rich cultural identity and heritage and to promote the social and economic development of our people and continue our connection to our lands. We accomplish this by providing a number of opportunities and benefits to our shareholders, from educational and professional development opportunities to cultural programs and resources. Perhaps one of the most meaningful benefits we provide is annual dividend distributions, which are a critical income source for many of our people. This is particularly true for our elders, many of whom live in our remote communities and face a harsh environment, limited transportation, supply chain challenges, surging living costs, and food security issues. Several of our villages have no or limited grocery stores and survive using traditional hunting and gathering practices. When the Alaska Native Claims Settlement Act was formed, it was expressly declared that the act would not diminish any obligation of the United States or of the state of Alaska to protect and promote the rights or welfare of natives as citizens of the United States or of Alaska. Yet today, our shareholders are being punished for receiving the very benefits, dividends they are entitled to due to outdated congressional legislation. Accepting dividends means our shareholders risk foregoing government assistance programs such as nutritional assistance, financial assistance under Social Security, and financial assistance or benefits based on need under federal programs or federally assisted programs. H.R. 437 would correct this oversight by amending ANCSA to permit Alaska Native elders to exclude settlement trust distributions when determining eligibility for certain government programs. It is my understanding that the effect of this bill on the budget is marginal, but the impact on our Alaska Native elders is significant. HR 437 as drafted is very narrow and applies only to elders 65 and over. For years, Congressman Young fought on behalf of Native people of Alaska, Hawaii, and the lower 48 states. He was a champion for Alaska Native rights for nearly the entire history of our corporation. Today, as we near Chugash's 50th anniversary, we ask you to stand with us in supporting HR 437 to continue honoring his legacy of support for our people. Thank you for hearing my testimony today. Koyana.
Thank you so very much, and thank you for once again pointing out we had a beautiful session of the Natural Resources Committee where we all shared our experiences and the role that those of us who are first serving as freshmen and freshwomen on this committee learned from our wonderful Dean Young and all that he taught us about his love for and his commitment to get things done for not just the Alaska Natives, but for all the Indigenous peoples of the lower 48 and of Hawaii. The chair will now recognize the Honorable Misty Napeahi, who is the Vice Chairwoman of the Tulalip Tribes, and I ask you for forgiveness if I mispronounced your name.
It's Napiahi, but good job. Good afternoon, Chairwoman Fernandez, Ranking Member Olbernodi, and members of the subcommittee. My name is Misty Napiahi, Vice Chairwoman of the Tulalip Tribes. I want to thank you for having this hearing on such an important matter for the Tulalip Tribes and other interested tribes in the Pacific Northwest. It's important to make clear that the Tulalip Tribes has never and does not oppose the Samish Indian Nation having the ability to have the Secretary of the Interior administratively acquire land into trust. We do, however, object to the bills that have been introduced over the past decade relating to the Samish Indian Nation that have focused on issues unrelated to trust land acquisition, specifically attempts to use the legislative process to alter longstanding case law in US v. Washington treaty fishing and other federal court litigation. Even with these concerns, we've offered revisions to the bill language that would have allowed the Samish to have certain lands legislatively acquired into trust status while not affecting our treaty rights. As introduced in this Congress, HR 6181 would ratify and confirm a November 9th, 2018 decision of the Bureau of Indian Affairs Northwest Regional Director to acquire a 6.7 acre parcel of land into trust for the Samish. In finding that the Samish Indian Nation was under federal jurisdiction in 1934, the decision relies heavily on the proposition that the present-day Samish is the successors in interest to the Samish and Nuwaha signatories of the 1855 Treaty of Point Elliott. This decision is being appealed in the Interior Board of Indian Appeals. This decision conflicts with the U.S. Department of Justice's longstanding position and the federal courts in U.S. v. Washington and 5 other federal court cases that have held that Samish Indian Nation is not a successor in interest to any treaty signatory. Rather, the courts have held that Swinomish, Lummi, and the Upper Skagit Indian tribe are the legal successors to those Samish and Nuwaha tribes that have participated in the 1855 treaty. Just 2 days ago, the U.S. Supreme Court let stand the Ninth Circuit's decision in the Snoqualmie case that reaffirmed that the Samish is not a successor to any tribe or band that participated in the Treaty of the Point Elliott and Snoqualmie Indian Tribe v. Washington. If HR 6181, as introduced, were to become law, Samish could argue that the Congress's action in ratifying and confirming the regional director's decision legislatively changed the underlying facts on the successorship issue and provide a basis to reopen US v. Washington and assert treaty rights based on this subsequent change in law. This would have settled expectations of the area tribes regarding their respective tribal identities. It would also result in modification of the Tulalip tribes and other individual tribes' established fishing areas. The only reason for HR 6181 to be drafted in such a way to explicitly ratify the regional director's November 9th, 2018 decision into federal law would be to rely on the wrongful findings about successorship and use the change in law to reopen a door long since closed and relitigate relitigate the successorship issue and treaty rights. For all of those reasons, the Tulalip tribes and other concerned tribes have opposed HR 6181 as introduced. The Tulalip tribes' concerns with Representative Gallego's amendment in the nature of a substitute are directly related to our objection to HR 6181 as introduced. The draft amendment would reaffirm the applicability of the IRA to the Samish without altering the now under federal jurisdiction requirement. Except for the regional director's November 9, 2018 decision, the applicability of the IRA to the Samish has not previously been affirmed. It could be argued that what is being reaffirmed by the amendment is the regional director's determination, which incorporates the decision that the Samish was under federal jurisdiction in 1934 as a successor to the Treaty Samish and Nuwaha. Again, despite more than 4 decades of federal court decisions to the contrary. Like we have previously said, Tulalip intends to work with other interested tribes, as well as Representative Larson's office and the committee on revisions to the amendment that would fully address our concerns. This concludes my testimony. I would be happy to answer any questions the subcommittee may have at this time. Pequotseed.
Thank you, Vice Chairwoman Napiahi. See if I got it better there. The chair would now like to recognize the Honorable Tamara St. John, who is a representative from the South Dakota State House of Representatives, for 5 minutes.
Good afternoon, Chairwoman Legger Fernandez and Ranking Member Obernolte and the members of the subcommittee. Thank you for this opportunity to testify in support of Senate Bill 789, repealing existing substandard provisions, encouraging conciliation with the Tribes Act, also known as the Respect Act. I wish to also thank Senator Rounds, who represents my beloved state of South Dakota, for providing the leadership in this important legislation. The Respect Act can be a base for further work to amend or change federal policies that limit the progress of Native nations and Indigenous people in the United States of America. Many of us in the Great Plains and across the country are excited to see the Respect Act finally receive a hearing in the United States House of Representatives. My understanding is that this legislation originated out of tribal consultations when Senator Round's staff was working with the Sioux tribes located in present-day South Dakota on Carlisle Indian School repatriation efforts. I've often heard it described as being a rare, nonpartisan, non-controversial, and no-cost piece of legislation. I thank all of you for giving this legislation the opportunity to be heard. In 2018, I was elected to my first term in the South Dakota House of Representatives. The day that I stepped onto the floor of the State House, I looked up and saw a painting of the sort that's commonly found in many state capitals or courthouses, and done during a time when life was very different in South Dakota. It depicts the typical images of immigrants during the time of settlement on what was once Native homelands for centuries. In the painting above my desk on the House floor is a Native woman with braids covering her bare chest. There also exists a similar painting of a non-Native woman in another location in the capital, and neither would likely be chosen today to portray the women of South Dakota. It's very clear to me that this place wasn't built with me in mind. As a woman in the United States during the late 1800s, early 1900s, I would not have been able to vote until the passing of the 19th Amendment. As a Native American, I would not have been considered a U.S. citizen until 1924. So as a society, we continue to grow and to change as needed. In America, when we know better, we do better. And Senate Bill 789 does just that. It represents the acknowledgement of a past that created hardship and even devastation for Indigenous people in the United States. As a historian, when I relay the history of Native nations, it corresponds directly with federal Indian policies, such as the Indian Removal Act. My own Dakota tribe was removed from the state of Minnesota in 1863 after the Dakota War, where Governor Ramsey called for the extermination of the Dakota. From that era of genocide, we moved into a period known as assimilation. It's from this area that some of the laws identified in the proposed legislation come from. the era of boarding schools where many Dakota children were forcibly removed from homes and families to be placed in schools as far away as Carlisle, Pennsylvania. The impacts of this policy are still found within our families today. For example, in 1889, Indian Commissioner T.J. Morgan numbered several ways in which assimilation would be carried out. Things that separated children from communities and broke down the native families and our kinship systems, outlawed such things as traditional languages as well as spirituality. The last paragraph I thought was most telling. It stated the autonomy of the individual will be enforced above all, end quote, meaning that a person is stripped bare of all things that identify them as a Native American person or an Indian person. When these children returned home, as you can imagine, they were often disconnected from their people and families. As one elder once told me, quote, "I knew I did not belong with my people. I knew I did not belong with white people. I didn't belong anywhere." Or how do you show love or connection when you've never experienced it? And this affected my every relationship from marriage to parenting, end quote. These are the same policies that resulted in a loss of spirituality or prayer. Due to the consequences of these antiquated and overly racist laws against Native Americans that are still on the books today, you can imagine how much Native people have had to overcome in order to be here today. In conclusion, we can't change the past, but we can certainly recognize that today as a nation, we know better and can do better. With these things in mind, I ask you to please vote in support of Senate Bill 789, and let's get this legislation to the President's desk. Thank you.
Thank you very much, Representative St. John. I thank the panel of witnesses for their testimony. I'm going to remind the members that Committee Rule 3D imposes a 5-minute limit on questions. The chair will now recognize members for any questions they may wish to ask the witnesses. I would also point out that given the number of bills and witnesses we have, we recognize that we might not get, in fact, I understand that I might not get to all the questions and witnesses that I would like to ask of the witnesses, that we do have the ability to submit written questions later. I will start by recognizing myself for 5 minutes. Chief Langford, I wanted to go back and think about the manner in which the United States broke its treaty promises to the Miami tribe of Oklahoma regarding the land in present-day Illinois. And you pointed out the history of the broken promises, the broken treaties. But your statement also then highlighted the fact that there are now clouded property titles for private landowners in the historic Wabash River watershed. How would the legislation, could you just clarify again how this legislation will resolve the uncertainty facing these private landowners?
Madam Chair, this is somewhat of a risk for my nation, this bill, because we are willing to give up the claim for our day in court. But just because we get our day in court, if this bill passes and the president signs it and we get it signed, that clears cloud on title because we give up the land claim. So all this bill grants to us is our day in court, and we still have to prove our case. But the landowners in Illinois, they receive, once it's signed, they receive immediate relief.
Right, and your testimony suggesting what Representative Young had said, that you have made the calculation that you need that day in court, and so you are willing to take that risk. And you've stated it again now, is that correct?
That is correct, Madam Chair.
I'd like to turn to the I'd like to turn now to the chairman of the Klamath tribes with regards to the difficulties that you are having with regards to having a say in how the benefits from the judgment fund are distributed to individual members. Your written testimony, pointed out the fact that many of those who should have been entitled to are passing away. And as you're looking at that judgment fund, can you tell us whether the Klamath tribes have a way of preventing non-native heirs from receiving payments from the tribal fund?
No, the Judgment Fund Act itself states that the funds would be distributed to 1954 members and their heirs. So we don't have the opportunity to exercise our sovereign authority and discretion to do what our memberships have voted to do. And that's voted to support providing those remaining funds, which came about at a time that were approved by our 54 members for the litigation use. And then there were some funds that resulted, some unclaimed funds that are subject to this. So we would be required without this repeal of the Judgment Fund Act to follow that act. And our members have supported the 54 members themselves, a subgroup or sub-entity of the Klamath tribes, voted to use those funds, which they authorized for the litigation purposes back when that was in play. But while there's still some remaining docket 100 cases, they're the ones that allowed those funds and received those funds to be used for the litigation purposes. So we wouldn't have the ability to do what our 54 members voted for, and our general council as a whole have voted for in support of our 54 members to provide those funds to the living, surviving 1954 members.
Thank you.
So we would be, okay, I think that answers it. Thank you.
Thank you so very much. I now want to turn to the Honorable Cheryl Kennedy, Chairwoman. This bill brings to our attention of this committee, like many of the other work that we do, that we're trying to rectify an error that the U.S. government made in years past. This is something that we have to deal with, like how do we fix these mistakes, these clerical errors, these unintended, with the unintended consequences that were really not meant to be. Can you talk to us about the history behind the drafting error that occurred before the Grand Ronde Reservation Act in 1994 and how that actually was conflicting with the intent of the legislation at the time?
Sure, thank you. I appreciate the question. The correction of the survey error came about when the BLM, of course, we worked in concert with them, and they came forward and identified that this error was existing. They actually brought the information to us. And so negotiations started between the BLM and the Confederated Tribes of Grand Ronde on how we could make whole this error that was made well over 100 years ago in 1871. So that negotiation started, and we know that our reservation has not been fully surveyed, so there are probably errors that we don't even know about yet. So that's the history behind it.
Yeah, thank you so very much. I see I have run out of my time, so I am not going to have a chance to ask for additional clarification on the clerical error with regards to, that was raised with regards to the Samish Indian Nation. But I yield back but the time that I no longer have, and I will now recognize the Ranking Member Obernolte.
Well, thank you, Madam Chair. I would like to start with some questions about H.R. 6181, and let me begin by saying that we who serve on this subcommittee do so because we are passionate about advancing the sovereignty of the tribes in the United States and solving the legal problems that have arisen over the years that prevent them from utilizing the lands that they're entitled to. And for me personally, nothing's more heartbreaking than seeing the times when our ability to do that is impeded by tribes not being able to get along with each other. So, I mean, hopefully we can catalyze, some discussions about that. Let me start with a question for Ms. Napiahi, and the only reason I got that right is because of the instruction from you, Madam Chair, but let me point out it's no more complex than Obernolte. So could you describe, you talked about the concerns that you had as a tribal entity with this bill as regards your tribal sovereignty. Could you talk about the revisions that the Tulalip tribes and the other Washington tribes are proposing that would address your concerns with this bill?
Yes. Representative Larson introduced a bill in the 116th Congress. Tulalip and others concerned tribes offered revisions that would have allowed Samish to acquire the 6.7 acre parcel into trust status, while including language that makes clear no treaty rights of any tribe would be affected. We never heard anything back from Samish after offering those edits to them. Before that, Tulalip and other tribes offered amendments to HR 2320 in the 115th Congress that would have had multiple parcels of land legislatively acquired into trust for Samish, while similarly including language that treaty rights are not affected. Samish rejected those revisions also. In each case, Tulalip and other tribes provided revisions that would have provided for land to be acquired into trust for Samish. So the assertion that the tribes have obstructed Samish's ability to get land into trust is simply not true.
All right, thank you. So next question for Mr. Wooten from Samish. Would the draft ANS that we're considering today allow Samish to obtain hunting or fishing rights through the courts or by any other means, in your opinion?
No, sir, it would not. Those rights have been decided by the courts multiple times in different arenas, referenced in the Tulalip testimony about the the U.S. Supreme Court case. So no, in no way does this bill impact treaty rights for any other tribe. It just reaffirms our ability to take land into trust under the current administration following the Carcieri analysis or impacts from the Carcieri case.
Okay, so it seems like this should be simple, because the other tribes say they have no problem with you being able to take the land into trust. You say you have no problem with having that affect another tribe's treaty rights. So would you be willing to accept language that would resolve this and make the other tribes comfortable by confirming that that their treaty rights are not going to be affected?
Ranking member, we believe that the ANS suffices, and it should make them more comfortable with the land going in trust for the tribe.
I mean, sir, you just heard testimony that they're not comfortable, and it seems like since we're all in furious agreement here, that the path of least resistance should be, let's get some language that clarifies what we all agree on and makes everyone comfortable, so that we can go back to advocating for your rights rather than trying to mediate a dispute between tribes.
So again, ranking member, we believe that the language is necessary to protect the tribe's previous feeder trust application, because it was taken in before the 2009 Carcieri opinion happened. And yeah, that's why that language is there. That's why the reaffirmation of the IRA is there, is to protect the existing tribal lands and the 6.5 acres going into trust.
Forgive my frustration, but we see this all the time. And the problem is when the tribes can't agree to get along, when everyone has the same goal, then what happens is everyone loses because legislation can't move forward. So I'm hopeful that maybe we can reach some language that everyone can agree with, since we all agree on the principles here. I see I'm out of time. Madam Chair, I yield back.
Thank you.
Thank you very much. The chair will now recognize the representative from Arizona, Mr. Gallego.
Yes, thank you, Madam Chair, and I'm also the sponsor of this legislation that has been ongoing for a couple years and has gone through multiple revisions, as well as amendments that we have taken in from tribes, not just Chileans, but other tribes, and have been quite accommodating. So we will continue to work, but to be clear, this is the accommodation. Vice Chairman, I have great respect to Toledo Tribe. I've actually worked with many of your tribal chairmen in the past, both in the private sector and in the government sector. and just want to say thank you for being here. I'm encouraged by your testimony that your tribe does not oppose the Samish taking in the 6.7 acre parcel. However, in order to do that, the tribe must use the IRA, Indian Reorganization Act. Like many tribes, Samish has been kept from doing so by the Kacheri versus Salazar decision, which is in part why I introduced this bill. Does your tribe support a Kacheri fix to allow Samish and other nations like them to take land into trust?
Tulalip, like many other tribes that have not had the carcieri decision prove an obstacle, has not taken a formal position on the carcieri fix bill because we haven't needed to.
So so unlike the hundreds of the tribes I've spoken to in the past 8 years that I've been on this subcommittee, the Tulalip are not for a Kacheri fix?
We're neutral.
You're, okay, well, that's interesting. Chairman Wooten, last Congress, I chaired a hearing on the Samish Indian Nation Land Reformation Act. This year, we're receiving testimony on a revised version of this bill that I worked on with the Samish Nation to further simplify the bill and address any lingering concerns. And I say again, any lingering concerns. Chairman Wooten, can you explain in more depth why Samish is seeking this ANS to the bill and what this ANS would do exactly?
So again, thank you for the question, Congressman. The bill is what it is. It's about taking land into trust for the Samish Indian Nation. As I explained in both my written and my oral testimony, that the tribe has had a long tortured history dealing with the federal government. And this would give relief for us for future applications to be considered to take land into trust for the nation. And that's all we're trying to do here. It's about land into trust. It's not about treaty rights or anything else. It's just about land into trust.
Thank you, Chairman. I just want to also clarify, our bill reaffirms the application of the IRA to the Samish because of the 79 acres of trust gained by the Samish tribe before the 2009 Kacheri decision. The IRA has already applied to the Samish in the past. So this bill no longer mentions the 2018 DOI decision, which was, by the way, one of the things that some of the opposing tribes asked us to do and incorporate. So that's why it's actually on this ANS. So even if it did, it would not threaten treaty rights, which are settled law. Chairman Wooten, in our conversations and in conversations with our offices, how many times do you think we actually incorporated some of the opposition's viewpoints into this bill?
Congressman, I would say every time that we received comments, we considered those and incorporated what we felt was applicable to the language of the bill. And of course, as you well know, the bill has changed several times. As the administration has changed, the rules, if you will, for land into trust has changed. And then, as you mentioned, in 2009, the Carcieri court case changed everything. And we were caught up in that. And again, it took us 9 years to generate the determination or the report for the BIA to consider us to even take land into trust.
And Chairman,
Yes,
can you
we've tried to accommodate.
let me gain my time back because I want you to elaborate on the quote-unquote clerical error that occurred by the BIA in 1969, which effectively left the Samish off the list of recognized tribes. What is that clerical error?
So again, the tribes up here in the Northwest are, there's 29 tribes in the state of Washington. In 1969, the Bureau transferred, a low-level clerk transferred the list of recognized tribes from one page to another and left off several tribes, well, 4 of them. Samish was one of those tribes. We did not discover that until 1973 when the US v. Washington case happened. So yeah, we've been fighting for this my whole existence as a tribal leader.
Thank you, Mr. Chairman. Madam Chairwoman, I yield back.
Thank you very much. And the chairwoman will now recognize Representative Radaragan.
Talofa lava. Good afternoon. Thank you, Madam Chair and Leisure Fernandez and Ranking Member Obernolte for holding this important hearing today. Thank you to the witnesses for testifying. My questions are for you, Chairman Beretta. As your testimony indicates, while the issue is very important to the Alaska Native elders the bill would help, the number of Native elders affected by H.R. 437 is quite small as a percentage of all Alaska Natives, correct?
Yeah, the life expectancy of our Alaska Native people is fairly low. And so from our corporation, the number is small.
Thank you. I realize there are a number of Alaska Native regional corporations, of which yours is one, correct?
Yes, we're one of 12.
And there are even a greater number of Alaska Native village corporations, as I understand it. But my question is, has your Native corporation actually experienced a situation where your elders have turned back settlement trust benefits?
We have had elders, yes, thank you for the question. We have had elders who have asked if they should give their shares away because the benefits that they were receiving were in jeopardy. And this is very troubling because a lot of these elders' benefits go towards basic needs for these for food and for glasses and just day-to-day benefits for these elders that live in these remote communities.
Thank you. Now, this question is for Cheryl Kennedy, Confederated Tribes of the Grand Ronde. Some tribes have expressed concerns to the committee that the gaming prohibition language contained in the bill would not exclude monetary awards from a land claim settlement that then could be used to purchase land for gaming purposes and use the Land Claim Settlement Act exception in the Indian Gaming Regulatory Act. Now, would you support amending the bill to address those concerns?
Thank you for the question. I believe that question has been responded to in the long report that has been submitted. Again, reiterated during my oral testimony today that we have agreed that that any settlement funds or any potential transfer of funds would not be used for gaming purposes. And I go on record right now in reiterating that is not what those funds would be used for. Thank you.
So, the Department of Interior has previously testified on the legislation, expressing concerns regarding the legislative history. Have you worked with the department since the 2020 hearing to resolve those concerns?
There has been correspondence between the agency and the Confederated Tribes of Grand Ronde. I believe at our hearing with the House, there was no opposition that was raised. So all of the issues that may have been there have been dealt with. Thank you for the question.
Okay, and this question is for Don Gentry, Klamath Tribes. Your testimony notes that the BIA and the tribe have made strenuous attempts to locate tribal members who were entitled to funds in the Klamath Judgment Fund. Can you elaborate on those efforts?
Yes, there are two different funds. There was significant effort on the unclaimed funds that was done by the BIA, and their responsibility to address unclaimed funds as a result of the litigation funds that were available. And so they exhausted and fulfilled their obligations to allow those funds to be potentially transferred to the Klamath tribes. In addition, the Klamath tribes, our folks have been interested in trying to help. So we've actually published several times in our tribal newsletter and got information out to our members, listed the names of the folks, the family names and the individual names for those unclaimed funds. So when we did that, we know we've gone beyond. In terms of the litigation funds, there was quite a bit of discussion on how to do that. If the litigation funds, which haven't been distributed, were to be distributed by the BIA, there would be an exhaustive effort to locate all the members and the shares and their heirs. And basically, there'd be a lot of money expended in that process. So that hasn't really been done. What we believe is appropriate is, since those funds were authorized for use by our 54 members, and we believe those funds should be under the authority or the direction of what the 54 members want to do. So we're intending to, if this legislation passes, distribute those funds. We take that burden upon ourselves and distribute those funds to the living 54 members and not go through an
Okay.
exhaustive process.
Thank you so much, Mr. Gentry. I'm way out of time. Thank you, Madam Chair.
Thank you. The chair will now recognize Representative Garcia from the state of Illinois.
Thank you, Madam Chair and Ranking Member, and to the witnesses who are with us today. We're here to discuss several tribe-related bills, many of which seek to rectify past wrongs. Committing to justice, however, requires more than merely acknowledging the mistakes of the past. While the legacy of injustices against Native Americans remains alive today, these bills are a first step towards achieving necessary measures of accountability. I'd like to begin with a question for Chief Langford. Thank you for being here and shedding light on a chapter of our country's dark history and the removal of your tribe from its ancestral homelands of the Great Lakes region. Can you share what H.R. 6063 to provide for the equitable settlement of certain Indian and land disputes regarding land in Illinois means for the Miami tribe of Oklahoma, and what challenges remain even if the bill were to pass?
Well, well, thank you for the question. The challenge is there's still a court case that we would need to prove and prevail. And so, that's really the last challenge, is to prove our case in court, which I wouldn't have asked to get this law done if I didn't think we could not prove that case. So that's really the biggest hurdle, is once the law becomes law, is to take this and go win our case, which we very much intend to do. I would, if I might make a statement, there was a mention by the ranking member about gaming. This bill has nothing to do with gaming, and I don't believe it has any bearing on the gaming. So I just would like to enter that. Thank you.
Thank you. And in your testimony, you describe that Congress has passed, quote, numerous judicial bills over the prior decades. H.R. 6063 is unique, close quote. Can you describe why H.R. 6063 is a different approach than previous bills and why Congress must pass this now?
One of the main reasons this is completely unique is the U.S. never purchased or ever paid anything for this land. It was never, we didn't cede it, and it was never paid. The tribe was never paid. So that makes it somewhat unique in that it was somewhat overlooked by the U.S. And the other unique thing about it is it helps the landowners in Illinois by clearing their title. That's one of the unique things that this bill does. It doesn't just help our nation, it helps the landowners in the affected area. That's what makes this very unique.
Great, thank you. For Senator Tamara St. John, thank you for joining us. Although the federal Indian laws of today uphold the principles of tribal self-determination and sovereignty, many enacted laws that reflect the prior federal areas of genocide, removal, assimilation, or termination still remain in the U.S. Code. Can you tell us, Senator, why it's important for Congress to pass S789, the Respect Act, despite federal Indian laws of today being vastly different from the outdated racist laws of the past?
Thank you very much for the question. I feel that it's very important because when you look at these particular sections of legislation where they speak to things that are like withholding rations or money, if a person were not to allow their child to be sent to boarding school, or in case of use of intoxicating liquors. Some of these things I think are so atrocious when you look at the details of them that it really does need to, these are things that I believe, of course, they're not enforced today. There would be a huge outcry if these things were enforced. But these are things that are very real when we work with history, such as Carlisle Boarding School. That's been an ongoing thing. And to know that rations were withheld or our children were held in boarding schools as a condition to the negotiations in a treaty. Those sort of things play into these too, and it would be fantastic. It would be a great start.
And in 5 seconds, what would passage of the Respect Act mean for you and the Dakota tribe?
I think it would mean that, first of all, it's acknowledgement of that these still exist. And the acknowledgement, it would signify a change to do better. I think that that's very important.
Thank you so much, Madam Chair. Thank you for your indulgence. I yield back.
Thank you very much. The chair would now recognize Representative Rosendale. Hello, for your 5 minutes. Now recognized for 5 minutes to question the witnesses. We can now move and recognize Representative Schroeder. If the witnesses would have patience for about another minute, we understand that the representative is on his way. Welcome, Representative Schroeder. That's fine. We will now recognize you for 5 minutes to question the witnesses. Welcome.
Can't hear.
That does help. Jeez. All right, the bill concerns 84-acre Thompson Strip, piece of Grand Ron's original reservation lands that was erroneously excluded in an 1871 survey of the reservation. And because it was not included in the survey of the reservation, the Thompson Strip was also excluded from a 1904 sale of the unallocated lands within the reservation, and Grand Ron was not compensated for it. Bureau of Land Management held the land and allowed 3 different private companies to harvest land and harvest timber on it, profits from which the tribe never saw any benefit. The tribe thus lost 2 avenues of compensation because of this simple survey error back in the day. BLM discovered the problem in 1988 and arranged a land exchange with Grand Ronde in which the tribe would receive 240 acres of BLM land contiguous to the present Grand Ronde Reservation in exchange for relinquishing their claim to the Thompson Strip. The land exchange was agreed to by the tribe and the Oregon BLM office as a dollar-for-dollar compensation for the Thompson Strip sale and lost timber income. In the 1994 legislation to effectuate this land exchange, the land was erroneously inserted that was erroneously inserted that relinquished Grand Ronde's right to bring any land claims in the whole state of Oregon, not just the Thompson Strip. No other tribe in Oregon has had their land claim rights extinguished for the entire state. The current statute is far broader than the tribe, BLM, or Congress or my state ever intended. The tribe's congressman at the time, Representative Mike Kopetsky from my district, confirmed his understanding about the land exchange and the extinguishment of claims to the Thompson Strip and testified before the same subcommittee, saying, under this bill, the tribe will relinquish their claim to the 84 acres in exchange for a parcel of 360 acres, later revised to 240, of BLM land, which is adjacent to the tribe's current reservation. Congressman Kopetsky's clear intent was for Grand Ronde to give up their claim to the Thompson Strip, not all the lands in the state of Oregon. Mark Mercier, then chairman of the Confederated Tribes of Grand Ronde, testified at the same hearing as Congressman Kopetsky. His testimony again makes clear that Grand Ronde intended to relinquish their claims to this land that was incorrectly surveyed and makes no mention of the rest of the state. Ron Scherler of the Oregon State BLM wrote in June 1994 memo that the land exchange bill should not extinguish all land claims in the state of Oregon and should apply only to the Thompson Strip. In agreeing to this land exchange in 1994, the intent of the parties was for Grand Ronde to relinquish its rights only to this strip, I keep saying that, and any claims for lost timber income. There's no intention to relinquish all rights. This bill would change the statute to that and read that the Grand Ronde relinquishes all claims to the Thompson land, not all lands within the state of Oregon. It's carefully written, the technical fix, trying to eliminate any possibility of unintended consequences or changes in land use. The bill would prohibit specifically Class 1 or Class 2 gaming, Class 2 or Class 3 gaming on any land or any land claim settlements that the tribe obtains to allay all concerns on casinos. This amendment to the Grand Ronde Reservation Act, simple, hopefully not controversial. The Senate passed S559 on May 26th. The House Natural Resources Committee held a hearing on the identical House version of my bill in the last Congress. Time to pass the legislation and correct this historic wrong once and for all. Thank you very, very much, Madam Chair.
Thank you, Representative. The chair will now recognize Representative Rosendale for 5 minutes, if you choose.
Thank you, Madam Chair. And I appreciate all of the witnesses and bearing with us, as now we are back in an active Congress, I will call it. So everybody's schedules are getting filled up again, and I apologize for not being here for more of the presentation. I do have a question for Don Gentry with the Klamath Tribes. If any of these individuals or their heirs' whereabouts are eventually known after the enactment of Senate 314, would they have a claim against the United States?
I don't believe so. I think the Bureau of Indian Affairs and their responsibility in finding the individuals is since passed. So, basically, folks, if they try to come after the fact, after the deadlines and the process is passed, they wouldn't have a valid claim.
Okay, that's, Madam Chair, I would yield back. Thank you so much.
Thank you very much, Representative. Before we conclude with the witness panel, are there any members who have not had their 5 minutes and who seek recognition to ask questions now? Then I thank the witnesses for their valuable testimony, for their patience, and I thank the members for their questions, which helped illuminate the issues over how do we address these issues so that we can correct those clerical and other errors that we have had in our history with regards to our relationship to our tribes and Native Americans. So as I stated before, the members of the committee may have some additional questions for the witnesses, and we will ask you to respond to these in writing. Under Committee Rule 3.0, members of the committee must submit witness questions within 3 business days following the hearing, and the hearing record will be held open for 10 business days for those responses. If there is no further business, without objection, the subcommittee stands adjourned.